afternoon, and welcome to OGE's Institute for Ethics in Government. My name is Patrick Shepard. We're very fortunate to be joined today by Seth Jaffe, the Chief of OGE's Ethics Law and Policy Branch. Welcome, Seth. We'd like to extend a warm welcome to some of our new viewers from the Inspector General community. We hope this is the first in many broadcasts that we're able to provide to you, and we hope you do find it helpful in your day-to-day work. And we'd like to welcome back some of our viewers from the ethics community who may have joined us before. So for new folks, welcome, and for those who have joined us before, welcome back. Before I turn it over to Seth and we get into the slide deck, I'd just like to make sure everyone is aware of the handouts they should have received. You should have received a PowerPoint presentation, which has the slides from today's presentation, as well as a PDF that includes some handouts that we will be referring to. We'd also like to take a moment to remind you that you'll be receiving a course evaluation at the end of today's presentation. We really value your feedback and use it to inform our schedule for future events and help us improve these presentations. So if you could take a few minutes to share your feedback and thoughts with us, we'd be most grateful. So Seth, shall we get into the slides?
Sure.
Excellent.
So as Patrick said, I'm Seth Jaffe. I'm the Chief of the Ethics Law and Policy Branch here at OGE. And thank you very much for attending this Advanced Practitioners webinar. Although today's presentation is primarily geared toward OIG officials, there is plenty of helpful information for agency ethics officials too. So today, we'll generally review who OGE is, OGE and ethics officials' role in conflict of interest investigations, how OIGs and the ethics community can work together effectively, and a review of ethics documents you can use in conflict of interest investigations. So more specifically, a focus of the presentation today is how OGE and the ethics community can assist in criminal conflict of interest investigations. OGE and agency ethics officials can provide tools to better conduct criminal conflict of interest investigations. Next, after briefly reviewing OGE's role in these investigations and referrals, we'll discuss best practices for IG's interactions with ethics officials in their agency, including potentially putting into place a memorandum of understanding between the OIG and the general counsel at the agency. And finally, we'll conclude with a review of what ethics documents exist in the community, where they are located, what information the documents contain, and how you can best use these documents in your conflict of interest investigations. So OGE in general. OGE was created by the Ethics in Government Act, 1978, the same year as the IG Act, as well as the creation of the MSPB and OSC. And this was done in the wake of the Watergate scandal in the 70s. Now, OGE has approximately 75 employees. We're all located in DC. And we have a presidentially appointed and Senate-confirmed director who's a member of the CIGI, the Council of Inspectors General on Integrity and Efficiency. Now, OGE is charged with the overall supervision of executive branch policy for preventing conflicts of interest. It's a decentralized ethics program with approximately 4,500 ethics officials spread throughout over 130 federal executive agencies. Now, OGE's primary role is prevention. We're focused on preventing conflicts of interest before they even occur. And there are several different components of prevention. The first component is that we oversee the financial disclosure system. Now, hopefully most of you are familiar with financial disclosure reports. I know that IG investigators generally fill out the 450 confidential financial disclosure report. Now, when I teach at the IG Academy, many of the investigators say that they've used these financial disclosure reports, public and confidential ones, in their investigations. And I'll go over a few examples later on. Now, in addition to the financial disclosure system being a component of prevention, another component is that we issue the standards of conduct regulations. In addition, we issue regulations interpreting the criminal conflict of interest statutes. We have a memorandum of understanding with the Department of Justice to issue prospective advice on 18 U.S.C. sections 203 to 209. In addition, in order to achieve prevention of conflicts of interest, we advise and train agency ethics officials, and we issue written opinions and other guidance. Now, in light of this prevention focus, we're not prosecutors, we're not investigators, we don't enforce the laws or rules. As you know, those roles are filled by the IGs, Department of Justice, as well as agency management involved in the disciplinary process. In fact, our statute prohibits us from determining that past conduct constitutes a violation of the criminal conflict of interest laws. Now, although we have this strong prevention focus, it is the case that in any given year there are many reported violations of the standards of conduct in the criminal conflict of interest laws. In a typical year, there are about 2,700 disciplinary actions based on the standards of conduct, and approximately 50 based on the criminal conflict of interest statutes. So, given this prevention role, what can we do to help investigators and the IGs? Well, first, there's the big picture. We know that without credible enforcement, our prevention efforts are undermined. Your work, and IG's work, is essential to the success of OGE's mission and the mission of agency ethics officials. Therefore, we are very motivated to help you. We frequently speak to groups of investigators, and we handle calls from IG officials on a regular basis. Now, next, OGE is an independent agency, and all that really means is that we're not part of another agency, and our director is appointed directly by the president. Sometimes we can help IG investigators with an independent or objective look at the facts of a case and act as a sounding board for IGs. Now, that being said, we strongly encourage IGs to work with their designated agency ethics officials and the ethics officials in their own agencies, because those officials have the agency-specific expertise to know whether specific actions might present a conflict for employees at that agency. And the ethics officials at the agency have access to agency-specific information, which we'll be talking about in the second half of this presentation. So I'd like you to take a second and think about the answers in your mind to these questions. So first, how many IGs officials out there know the name of an ethics official at your agency? How many ethics officials out there know the name of an IG employee at your agency? Do either one of you know how to contact each other? In a little bit, I'll discuss some of the reasons why it is definitely advantageous for both of you in the IG community and in the ethics community to consult with each other. And one thing I would like to mention, though, in this consultation role is that ethics officials do not represent the employees who they are giving advice to. So there's no attorney-client privilege between an attorney ethics official and an employee to whom they're advising. So if an IG needs information from an ethics official, the ethics office is obligated to turn over that information. And of course, we also likewise encourage ethics officials to work with the IGs. So let me talk a little bit about how OGE gets involved in the criminal referral process. Based on our statute, we are obligated to cooperate with the Attorney General to develop an effective system for reporting allegations of criminal violations. Therefore, we insist that agencies, especially ethics officials who are subject to our oversight, honor their obligation to refer criminal allegations. So 28 U.S.C. Section 535 requires every department or agency to report to the Attorney General any information, allegations, or complaints relating to violations of Title 18 of the U.S. Code. Now, the Director of OGE, in accordance with the Ethics in Government Act, has issued regulations requiring agencies to concurrently notify the Director when any matter involving a violation of 18 U.S.C. Sections 203 to 209 is referred to the Department of Justice. So I'd just like to repeat that. There are regulations that are issued in accordance with the Ethics in Government Act that require agencies to concurrently notify the Director of OGE when a matter involving a violation of the criminal conflict of interest law is referred to the Department of Justice. Now, that notification can be accomplished by providing a copy of the referral documents, but it's more commonly accomplished by submitting OGE Form 202 and submitting that form to OGE. And as part of the handouts and materials that were provided to you in preparation of this class, there is a sample of OGE Form 202. Now, OGE's regulations also require that the agency subsequently notify the director of OGE of the referral's disposition, including any disciplinary or corrective action taken by the department or the agency. So there has to be a concurrent notification of a referral, and there has to be a notification to OGE of the disposition of the referral. So in addition to that, we also can get involved in the criminal referral process by providing ethics officials advice on individual cases where they may or may not be sure that a referral is required either to the IG or to DOJ. And in some cases, we help agency ethics officials communicate with DOJ or with the IG to explain the basis of a legal referral. Now, sometimes, although not very often, we at OGE will also make a criminal referral to the DOJ directly if we have knowledge of the facts through our own review of financial disclosure reports. But as I said, that's extremely rare. So now I'd like to move on to talk about IG's interaction with agency ethics officials and agency ethics officials' interactions with IGs. Now, OIGs and DAOs should maintain ongoing communications, two-way communications. Now, there's a very important handout that was provided to you in preparation for this class, and that's a 2011 article in the Journal of Public Inquiry. It's called Growing Old Together, Inspector General and Ethics Council, Changing Environments and Challenges. This article can also be is also available at www.ignet.gov. And this is an article that was written by 3 different IG councils at different IG offices. And what this article goes over is how these communications between IGs and ethics community can help ensure that the ethics officials are aware of all the ethics infractions that they're required to catalog and maintain, and how this can lead to a better ethical culture at the agency. So these internal communications, are best to be put into writing as internal procedures, or potentially a more formal memorandum of understanding between the IG office and the ethics officials in a GC shop. And they tend to cover 2 large topic areas. One, it would spell out the respective roles of the IG and the GC office. Often it might indicate that they're, this audit and investigation function that lies with the IG and not the GC. It might spell out parameters of the interactions, as well as the nature of any potential legal services that the GC would provide to the IG office. And the second area, which is particularly important for the topic today, is the manner in which information is exchanged between the 2 offices. An MOU might include information about how to exchange information on the status of an investigation. It might also indicate which individuals are appropriate to be included in the exchange of information, maybe individuals who are not appropriate to be included in this exchange of information. In addition, the MOU might outline how communications will be shared between offices based on communications with DOJ, either communications to or from DOJ, and how each office keeps the other informed of these communications. Also, it would probably spell out how communications are between the 2 offices concerning any referrals to DOJ under 28 U.S.C. Section 535, as well as spelling out the requirement of the concurrent notification to OGE when a referral is made. In addition to that, the MOU could address how OGE will be informed if there's a subsequent indictment or other disposition of the referral, and how to inform OGE of any discipline or other final disposition of a criminal referral. Now, getting together with, having communications with, having a formal MOU between the 2 offices at your agency, the IG and the ethics office, can lead to a better understanding of the criminal conflict of interest laws. If there are occasions where there are certain sensitivities involved, you can consult with the ethics official at your agency or with OGE by using a hypothetical without revealing the names of any employees involved. Now, we at OGE are well aware of some of the obstacles IGs face when trying to comply with reporting requirements of criminal referrals to OGE. However, accurately and diligently and timely reporting these referrals and dispositions to your ethics office and to OGE are important for various reasons. First, if you make these timely and accurate communications about dispositions of referrals, then OGE and the agency can use that for training purposes, for training employees to try to avoid potential pitfalls. In addition, OGE uses the outcomes of these referrals and several prosecutions that result from them as the basis for our annual publication of the prosecution survey. And this prosecution survey serves a very important purpose of deterrent and education for all executive branch employees. In addition, by having this open line of communication, agencies might also decide whether or not they need to implement a supplemental agency ethics regulation based on the outcome of referrals. In addition, the ethics officials at the agency, if they have this open line of communication and a timely communication with the IG office about the disposition of referrals, can also lead to ethics officials knowing whether or not any other remedial action or corrective action needs to be taken on an individual case basis. And by having this timely interaction and continuous feedback loop into training, supplemental regulations, a deterrent and education effect, it all leads to a better ethical culture at the agency. So now I'd like to go on and talk about how OGE can help with understanding the laws that are out there. So first is the criminal conflict of interest laws. And as I said, although we're not prosecutors or investigators, we have a lot of experience in applying the criminal conflict of interest laws. We have this memorandum of understanding with DOJ to interpret these laws prospectively. And when I refer to criminal conflict of interest laws, in this case, I'm referring to 18 U.S.C. sections 203 to 209. Again, in the materials that were given out to you in preparation for this webinar, there's a one-page summary of the topics that are covered by these statutes. So sections 203 to 209 of Title 18. Section 203 deals with limitations on the ability of current employees to represent outside groups back to the government in particular matters in which the government is a party or has a direct and substantial interest in getting paid for that. 18 U.S.C. section 205 has similar limitations regardless of whether the current employee is being paid. 18 U.S.C. section 207 is the primary post-government employment conflict of interest statute, and that imposes limitations, among other things, on a former government employee representing third parties back to the government on particular matters, on party matters in which they participated in as a government employee. Next is the primary financial conflict of interest statute at 18 U.S.C. section 208. And that's the statute that prohibits a government employee from working on a particular matter that could have a direct and predictable effect on his or her own financial interests or the financial interests of individuals or entities that are close to them, like their spouse, their minor child, an organization with whom they're negotiating for employment. And finally, there's 18 U.S.C. section 209, which is a supplementation of salary prohibition. It basically says you can't get paid for doing your government job by any source other than the government.
And Seth, I find that handout to be very, very helpful when I'm looking at any ethics matters, because you can sort of use it as a checklist to ensure that you've considered all of the authorities, which is sometimes the biggest challenge, is just remembering what's out there.
Yeah, well, I think that's absolutely right. It's why we provide it to people. So we definitely, I like to second that, definitely recommend using that resource. So one example of an 18 U.S.C. 208 investigation and how an ethics document was used in that investigation is a couple years back, a FEMA employee had an arrangement for future employment with the Gallup polling organization. And while he had this arrangement, he he was simultaneously negotiating a contract on behalf of FEMA with the Gallup organization for Gallup to come in and take a survey of FEMA employees. So when this came to light, it actually came to light because a Gallup employee was concerned about this. The FEMA employee pled guilty to violating 18 U.S.C. 208 because he participated in a particular matter, the contract, that had a direct and predictable effect on his future employer. But in addition, he failed to disclose the future arrangement for employment on his financial disclosure report, which was required. So that also formed the basis of his conviction and pleading guilty. So this is one example. We'll talk about some more examples about how financial disclosure reports and other ethics documents can play a role in supporting a criminal conflict of interest investigation. So OGE has issued regulations interpreting 18 U.S.C. 208. We've issued regulations interpreting 18 U.S.C. Section 207, and we're always willing to help investigators and prosecutors understand how these criminal conflict of interest laws might apply to a particular case that they have. In fact, we provide that type of assistance pretty much every week. In addition, there are criminal penalties that are in the Ethics in Government Act for filing a false public financial disclosure report, and that's in addition to the laws that are already on the books or earlier on the books concerning false writings at 1018 and a false statement at 1001. Now, in addition to the criminal laws, there's also the standards of conduct that we can help investigators understand better. A lot of times you might be doing an investigation, you believe that it's possible that a criminal law has been violated, but the investigation actually leads to potential violations of the standards of conduct and not a criminal law. Now, these standards of conduct cover a much broader range of behavior, largely because they're not criminal. They cover such things as receiving gifts from outside sources, prohibited financial holdings, impartiality limitations, seeking future employment rules, using public office for private gain, limitations on various outside activities, including fundraising or teaching, speaking, or writing. Now, let me just talk about one example of an investigation that led to disciplinary action based on a violation of the standards of conduct. A little while back, there was an EPA attorney, and this EPA attorney was representing another EPA attorney in a family law dispute. And during this family law matter and this representation, there was a fee dispute between the two EPA attorneys, the one being represented and the one doing the representing. As a result, the attorney who was being represented in the family law matter complained to the EPA. The subsequent investigation led to a discovery that the initial attorney who was representing the other attorney was basically doing the outside practice of law and doing that based from their EPA office using government equipment and time. Now, there are a lot of standards of conduct, potential violations and actual violations that this was related to. It was misuse of official position, misuse of property, misuse of time. There may have been a supplemental reg requiring prior approval for outside activities. The outside activity may have conflicted with their official job duties. But the result of this, that although there was no criminal violation, the EPA attorney who was doing the representing was disciplined, in fact, was fired from their job. And, of course, OGE can help investigators understand how these rules might apply to scenarios in which you're working on. Now, one thing I do want to mention is that there is one safe harbor provision as it relates to the standards of conduct. If an employee goes and seeks advice from their ethics official and they disclose all relevant facts to the ethics official, and the ethics official gives advice that says, the employee can do X, Y, or Z, and the employee does that, but it turns out to be a violation of the standards, then they have a safe harbor from being disciplined for violating the standards. If, on the other hand, it leads to a criminal violation, although there's no safe harbor provision for poor advice, prosecutors would generally use their discretion not to prosecute in that situation. And in a little bit, we'll talk about a couple of examples where ethics officials were asked advice by employees, and the employees were less than forthcoming in the information they share with the ethics officials and the effect of that.
So that's a key piece of information, is they have to disclose all of the relevant facts, and they can't withhold the information in order to receive the safe harbor.
That's absolutely right. So moving on. So this last section of the webinar today is extremely important because it provides practical tools that IGs can use in conducting criminal conflict of interest investigations. Now, the Executive Branch Ethics Program relies on numerous documents that can be relevant to IG investigations. Now, OGE can help investigators locate some of these documents. Some will be in the possession of OGE, although many will be in the possession of the agency ethics officials. And agency ethics officials actually can be more helpful in helping IGs locate the majority of ethics documents that are out there. Now, the ethics officials at your agency, as well as OGE, can help you understand the documents, the context in which they're used, and what information should or should not be on those documents. Now, there are a lot of documents that we're going to go through fairly quickly today. We have the public financial disclosure reports, the confidential ones, ethics agreements, the ethics pledge, outside activity prior approval forms, conflict of interest waivers, training files, and advice files and opinion letters. Now, I'd like you to just take a second and think to yourself, how many of these documents am I familiar with? Have I even heard of all of these documents? Typically, when I teach the IG class at the IG Academy, most of the investigators there are familiar with some, but not all of these documents. And that's why I want to go over them today. But let's start with one document that you probably all know, and that's the Public Financial Disclosure Report, the OGE Form 278. Now, just one note, this form is changing. It's already being rolled out in a new format and will, over time, gradually replace the 278 and be the 278E. The information reported on the 278E will be identical to the information on 278. That's because the statute requiring disclosure hasn't changed, but the format has changed, and it'll be easier to fill out for employees. So this format might change in the near future. If you're using them to in an investigation, you might see a different format soon. Now, the presidentially appointed and Senate confirmed employees fill out one of these public reports with the agency and with OGE. About another 26,000 filers file this report, but they file it directly with the agency and it never comes to OGE. There only are about 1,000 or so of the presidentially appointed Senate confirmed filers. Now, in 2012, the Stock Act was passed, and that requires these filers to update sales of stock and certain other sales transactions on a monthly basis. Now, there's a lot of information on these reports, as many of you know. There's the individual's assets, their income, their liabilities, entities or individuals to whom they owe money, outside positions, transactions, and gifts. It's a snapshot in time of their financial situation. And these reports are retained for 6 years. Mostly they're at the agencies. Some of the PASers would also be at OGE. Now, your ethics official at your agency, as well as OGE, can help you understand what is required and what is not required to be on these reports. Now, financial disclosure reports have very frequently been useful tools in public corruption cases or criminal conflict of interest cases. Now, in the legislative branch, Congress people are also required to fill out this form. And recently, Senator Robert Menendez was indicted in April of last year on bribery charges. The allegation, yet to be proved, is that he accepted jets, vacations, and contributions to his campaign for intervening on behalf of a donor's girlfriend and intervening in a multi-million-dollar Medicare billing dispute. Now, in 2007 to 2011, he did not report these benefits that he received on his financial disclosure report. And the point here is that just because a gift or other income or assets may have been obtained illicitly, that doesn't absolve them from being needed to be reported on the 278. Very often, it's actually easier to prove a false writing or willfully and knowingly filing a false financial disclosure report than it is to prove the underlying offense that's being investigated. So we'll move on to the confidential report. Now, confidential reports are filled out by well over 300,000 executive branch employees. These are generally filed with the agency, generally not with OGE, and they're retained for 6 years. The information on these forms is similar to the information on the public forms, although less detail is provided on these forms. In addition, I'd just like to note that the Stock Act monthly reporting requirement for transactions does not apply to the confidential financial disclosure report. So again, OGE or ethics officials at the agency can help IGs understand what is supposed to be on this report and what's not supposed to be on this report. Now, let me talk about an example where a 450 report was used in an investigation. A few years back, an FDA chemist had access to information at the FDA about which drugs were about to be approved or not approved and when. Obviously, this is very valuable information to have access to. And he traded on this inside information for many years. As a result, over the course of many years, he made about $1 million of gains on his trades based on this insider information. Now, when this came to light, he was convicted of insider trading, but he was also convicted for filing a false financial disclosure report because he did not report these illicit gains on his confidential 450 report. Again, although insider trading was proved in this case, it's often easier to prove a failure to file or filing a false financial disclosure report than it is to make the underlying case of an investigation. So let's move on and talk about ethics agreements. Now, ethics agreements are the type of document that you may or may not be really familiar with if you're in the IG community. In part, that's because the vast majority of executive branch employees do not have an ethics agreement. Typically, presidentially appointed and Senate confirmed employees have an ethics agreement. So that's the very highest level executive branch officials, and some other officials may have one also. Now, what is an ethics agreement? An ethics agreement is an agreement between the employee and the agency, or OGE, and the administration, if it's a PAS official, to take specific actions to prevent conflicts of interest or the appearance of conflicts of interest before they occur. Generally, the employee has 90 days to comply with the terms of his or her ethics agreement. So an ethics agreement will oftentimes require an employee to take certain steps to prevent the conflict from happening. So it might say you'll have to sell certain assets. You might have to recuse from working on certain matters in your job. You might have to resign from certain outside positions. Now, obviously, if you're doing an investigation of an official who has an ethics agreement, it's very important to know that it exists. And it can be a great time saver because in some ways it provides a roadmap to a potential prosecution. Because again, what is the ethics agreement doing? It's identifying an ethics concern that's specific to a particular employee. It outlines the steps that that employee will take to mitigate the ethics concern. And it states the possible laws that could be violated if they don't take these steps. And then the official signs the document. So take an example. Say you have a nominee to be the incoming Secretary of Energy. And that person is the CEO of an energy company and holds stock in the energy company. Now, when that potential nominee is working with OGE and the ethics official at the Department of Energy, they will reveal this information in their financial disclosure. At that time, the ethics official in OGE would identify an ethics concern. You're going to be the Secretary of Energy, and you are the CEO of an energy company and own stock in that company, so that's a concern. Now, the ethics agreement might outline the steps to mitigate the concern. Basically, it will say you're going to resign from that outside position as the CEO. You're going to sell the stock of that company, and you're not going to work on party matters that affect that company for 1 year under the standards of conduct, and for 2 years under the ethics pledge. So those are the outline of the steps that are going to mitigate the concern, and it's going to state the laws that could be violated. Again, 18 U.S.C. 208, the impartiality standards and the standards of conduct, and the ethics pledge, and they sign the document. So obviously, you would like to know if someone for whom you're doing an investigation has one of these ethics agreements. These are retained for 6 years, sometimes longer. They're at the agency, and for a presidentially appointed Senate confirmed, most of those would also be on OGE's website. So let's now talk about the ethics pledge. I'm not going to talk about this very long, except to say that the ethics pledge applies to full-time political appointees who are appointed by the president. This comes from Obama's executive order that he signed on his first day of office, Executive Order 13490. And among other things, it extends limitations on the ability of pledge signers to receive gifts from lobbyists. Violation of the ethics pledge is not a criminal matter. And there's also a waiver provision where certain officials have received a waiver from the ethics pledge requirements. Not usually a waiver to receive gifts, but a waiver for other provisions. And those waivers are also can be found on OGE's website. So now let's talk about outside activity prior approval forms. Now, as I mentioned before, some agencies have supplemental rules, supplemental agency ethics regulations that are published jointly with OGE that require employees to obtain prior approval before they engage in certain outside activities. It could be an outside business activity, it might be outside teaching, speaking, or writing, or it could be just outside employment. Now, if they have this requirement, they'll typically have a requirement that the employee fill out a form stating the nature of the outside activity, the nature of their current job, so the ethics official at the agency can determine whether or not to provide approval before the person engages in the outside activity. Now, these forms are typically kept at decentralized locations. In other words, they're at the agency, they're not at OGE. They're usually retained for 6 years. And the information on the forms, of course, is the type of information that's relevant for the agency official to determine whether or not the outside activity would pose a potential conflict. Now, obviously, in the IG community, if you're doing an investigation of an employee who has an outside activity, and that's the nature of your investigation, you're going to want to know whether or not prior approval was required by the agency, and if the person submitted the form. You're also, of course, going to want to know whether the information on the form that was submitted was accurate. And all that type of information will be extremely helpful to you in an investigation of an employee who has outside activities. So next, I'd like to move on to conflict of interest waivers. Now, this is another document out there that is possible that some of you may be familiar with and some of you might not be familiar with. And again, the reason is somewhat similar to ethics agreements in the sense that there aren't necessarily a lot of conflict of interest waivers, but when they do exist, they can be particularly important. And that's because of a couple of things. But before I get into that, I just want to back up for a second and remind people that the primary financial conflict of interest law is 18 U.S.C. 208. That's the law that says you can't work on a particular matter that could affect your financial interest or the financial interests of individuals or entities who are close to you, like your spouse, minor child, entity with whom you're negotiating for employment. However, 18 U.S.C. 208 has a waiver provision, and it says that notwithstanding a conflict, you can work on a particular matter if you get a waiver, and you can get a waiver if the conflict is not so substantial as to call into question the impartiality of your actions. So in order to get a waiver, there has to be a conflict. So if you don't have a potential criminal conflict to begin with, you can't get a waiver. So if you're investigating someone who you think has violated a criminal conflict of interest law, then you want to know whether they had a waiver to actually engage in that activity. It's not likely that they will, but you'd want to know.
Absolutely. That makes a lot of sense because you may happen upon a fact pattern that's an apparent conflict and the waiver has been provided and actually there's no problem there at all. So a good question to ask so you save yourself some time.
Exactly. So now waivers cannot be granted retrospectively. So in other words, an employee has to either go to his ethics official ahead of time and spot that they might have a potential conflict with an assignment they've received or an assignment they want to work on and say, I have this conflict, can I get a waiver? Or it might happen where a supervisor is aware, based on a financial disclosure report or based on some other means, that this person has a conflict and says, I'd like to assign you to this. I know you have a conflict. Let's see if we can get you a waiver. But the point is, it has to be issued prospectively. It can't be issued retrospectively based on the same facts where a violation has already occurred. Now, the waivers are kept for 6 years, and they're kept at the agencies typically. Now, agencies are supposed to consult with OGE on the issuance of the waiver, because the agency issues the waiver, not OGE, but they consult with OGE where practicable. So many of the waivers will be in the procedure, in the context of a consultation with OGE, but ultimately the agency issues the waiver. Now, let me talk about an example where this might come into play. Now, it's possible that you might be investigating a Department of Justice attorney who has worked on a criminal prosecution of a company with whom the attorney has owned stock. So that it would appear to be a violation of 18 U.S.C. 208 because they've worked on a particular matter, a criminal prosecution that would affect the financial interests of a company in which they own stock. No, it's their own financial interest. However, if the DOJ attorney didn't own a lot of stock in that company, and it was a very large company, maybe a very small prosecution, and didn't work on the case yet, and went to their ethics official, it's conceivable they could have gotten a waiver to actually participate in that prosecution because the ethics official determined that a reasonable person would not call into question their impartiality by working on that prosecution. So obviously you'd want to know that if you were doing that investigation. Next, training files. And every time I share this slide, I just always point out to people that every ethics training that I've ever conducted, all the people attending the training always look that happy. They're always smiling that much. I'm sure if we had a camera pointed all at you right now, it's exactly what we'd see. And they're all smiling because they're required to have an initial ethics orientation when they come on board. And as you know, many employees are required to receive annual training. Now, this is another reason why it's in the interest of both offices, IG offices and ethics officials, to work together. Especially IGs should be aware of these training files and who has received training and when. Just like to say that a former DOJ public integrity prosecutor who used to work at OGE once told me that he used a video of an ethics training at a conflict of interest trial to show that the accused specifically had asked a question concerning a provision of 18 U.S.C. 208 for which he was being prosecuted. Now, if you aren't lucky enough to have the video, you might be lucky enough to have the attendance sheet, because attendance sheets are passed out. Very often the topics that are covered might be indicated on that sheet. And of course, if you're doing an investigation, it might be helpful to know that someone had recently received training on the very topic for which you're investigating them. Now, in addition to the initial training, I mentioned some officials receive annual training. Public financial disclosure filers are required to receive annual training. Now, the records of these trainings are supposed to be kept for 6 years. They're kept at the agencies. They won't be at OGE. But of course, you'd like to know who's attended training and on what topics. Now, finally, I'd like to talk about advice files. Advice files are a very important document that can provide a tremendous amount of help to IGs in investigations. Now, OGE and ethics, agency ethics officials keep files on advice given to employees, although ethics officials typically give the advice directly to employees, and OGE gives advice to ethics officials. Now, OGE has encouraged agency ethics officials to make a written record of advice given to specific employees, although we recognize that this might not always be feasible. Now, the advice, though, that's given to employees directly by ethics officials that's been committed to writing is generally retained for 6 years, although routine advice not involving criminal conflict of interest laws might be retained for 3 years. And as I said, advice files are a very important tool, and one more reason that there should be this open line of communication between IGs and ethics officials. So let me give you an example of a prosecution that relied on advice files in the prosecution. And of course, it does have something to do with that picture that's on your screen. On the second to the right is David Safavian, wearing a black shirt and white hat. He was the chief contracting officer at GSA a while back. And he went to his ethics official. He said, I've been offered a free trip to Scotland to play golf and have some other activities while we're over there. I've been offered that by Jack Abramoff. Jack Abramoff is the person in the far left in the black shirt and the white hat. I don't know what it is about black shirts and white hats. It's kind of ironic they're both wearing white hats. But in any case, he said, I've been offered this present, this gift by Jack Abramoff. So the ethics official asked a few questions. Said, well, is this Mr. Abramoff doing business or seeking to do business with GSA? And Mr. Safavian said no. He said, well, is Mr. Abramoff, is he a close personal friend of yours? And the relationship would justify the giving and accepting of the gift. And Mr. Safavian said yes. Well, subsequently, it was turned out that those answers were lies. Mr. Abramoff was seeking to do business with the agency. In fact, he was trying to rent the old post office building, the building that's going to be turned into a luxury hotel currently. He's trying to rent that for $1 a month. That was his offer. And he also was not a close personal friend, and in fact was a lobbyist, was not a friend of Mr. Safavian. So after several different investigations of this and other allegations, Mr. Safavian was found guilty of obstruction of justice, influencing an IG investigation at 1505, and making false statements at 1001. Now, this advice that was going back and forth between Mr. Safavian and his ethics official was all in emails and was in the ethics advice files. So this back and forth in the ethics advice files was evidence that was used in order to convict Mr. Safavian of making false statements. Now, opinion letters may also be located in advice files. And opinion letters are letters that are given to individual employees, often giving an opinion on the application of a criminal conflict of interest law to a specific situation in which the employee is seeking advice. So many of you may be familiar with Darlene Druyan. Darlene Druyan was a former lead acquisition official at the Air Force. And when she was the lead acquisition official there, she was negotiating a multi-billion-dollar tanker deal between the Air Force and Boeing. Now, she also went to her ethics official, just like Mr. Safavian went to his, and told the ethics official that she was negotiating for employment with a lot of different entities. She failed to mention that she was negotiating with Boeing. So, but she got advice on whether she could participate in this tanker deal, and there was a 208 opinion that was issued to her. As it turned out, as I said, she actually was negotiating for employment with Boeing, in addition to the fact she was negotiating for employment for her child at Boeing, also failing to notify her ethics official. So ultimately, she was convicted of violating 18 U.S.C. 208 because she was working on a party matter, the contract, that affected the financial interests of an entity with whom she was negotiating for employment. She also had other issues about lying to her ethics official and lying to others, and she was ultimately found guilty and went to jail for violating that statute. One final area where opinion letters are common, especially at DoD and other agencies, is giving advice on 18 U.S.C. Section 207, post-government employment limitations to employees who are planning to leave the government and go work for outside entities. And very often, an official will come to their ethics official, an employee will come to their ethics official and say, well, I'm retiring, I'm leaving soon, I'm going to go work for this company. And a lot of times they go to work for contractors or companies that are doing work in an area that's similar to the work they're doing now. It's part of the reason they were attracted to be hired by that company. So they want to know what they can and can't do when they go to work for that company. And in fact, that company wants to know that too. So an opinion letter would be issued to that individual and put in the advice file. So if you're in the IG community and you're investigating a former employee and trying to figure out whether they're violating 18 U.S.C. 207, representing a company back to the government on something they may have worked on when they were there at the government, you certainly want to know whether a 207 opinion letter is in the advice file.
And I think we're seeing these more frequently where employers in the federal sector are becoming very sophisticated about requesting this information, because it can be quite costly for a private company to hire someone who's unable to perform the work that they've been hired to do. So I think that's a trend that we're going to continue to see.
Okay, so in conclusion, there are a few points I would like you to take away today from this Advanced Practitioners webinar. First, if you're in the IG community, be sure to communicate with your ethics official when you're pursuing conflict of interest investigations, letting them know about the criminal conflict of interest referrals to DOJ and the disposition of all the matters that they've referred to your office. Certainly, it would be helpful for both offices to commit to writing internal procedures about the nature of communications between the offices and potentially have a more formal memorandum of understanding of these procedures, because of course, communication is always a two-way street. Next, please be aware to take advantage of the documents in the ethics community that can help you with your conflict of interest investigations. And finally, feel free to contact OGE if you want to consult on the application of the criminal conflict of interest laws and the standards of conduct regulations.
Excellent. Well, it looks like we have just a couple of minutes left before the top of the hour. We'd like to go ahead and open up the phone lines, Crystal, for any questions. And those of you on the Hangout, if you have any questions, you can type them in the questions app in the lower right-hand corner of your screen.
Thank you. To ask a question from the phone lines, please press *1. You will be prompted to unmute your phone and record your name. Again, it's *1 to ask a question. One moment, please, for the first question.
Great. Thank you, Crystal. And thank you, Seth, for joining us today. I think we had a huge amount of interest in this presentation, and hopefully this provides folks with a framework and understanding of the tools the ethics program can make available to inspectors general as they conduct investigations of conflict of interest laws and the standards of conduct. And I'm not yet showing any questions on the Hangout. Do we have any questions on the phone, Crystal?
No, sir. There are no questions from the phone lines at this time.
Okay. Well, thank you again, Seth. And I hope this is the first of many presentations that we can provide to the Inspector General community. And we'd also like to make you aware that if you'd like to learn more about any of these laws and regulations, there's a wealth of resources on the Institute for Ethics in Government's YouTube channel, which you can find at youtube.com/OGE Institute. There you can find detailed discussions of each of these rules and many of these forms. Hopefully you'll find those to be helpful in your investigations. So thank you very much, and we'll see you next time.